And hey everybody, welcome back to the Law and Crime Network. I'm Michel Bryant with you for this Monday afternoon. I hope you had a great weekend. I spent some time with you on Saturday morning as we continue to watch the Amber Guyger case unfold. No more critical testimony from the defendant than that right there. What was she doing at the moment, 10 o'clock that night in September 2018, before she entered the apartment of Botham Jean? This is the stuff the jury's having to deal with, the reasonableness of those actions. Luckily for me, I've got a couple of folks on hand that can help us go through this. I have Michele Rayner-Goolsby, a civil rights attorney. Good to see you again, Michele.
Good to see you. Good to see you.
And Leslie Ricard-Chambers. In fact, for today, if you don't mind, ladies, I'm going to be known as Michel James Bryant. So I'm not outnamed by you guys. 3 names for everybody. Let me start with you, Michele, because you recently were involved in the case against Michael Draka as a representative of the family members of the victim, Marquise McLaughlin. That case ended with a guilty verdict. Just briefly, where's that civil case now? How's the family doing?
Right now, we are obviously in the throes of civil litigation. We're doing our pre-suit, work that normally happens. The family's doing well. We have sentencing that's coming up on October 10th. So we are right now just looking forward to that. And it's really interesting because, for this particular case, the McLaughlin case, I had to take off my criminal defense hat and put on my civil rights attorney hat, and kind of, seeing, some of the similarities in the Botham Jean case. When we talk about reasonableness, was it reasonable for, Ms. Guyger to do what she did? It's kind of the same themes that were in the Marquise McLaughlin case.
Yeah,
so right now.
Yeah, I was going to say that's a perfect transition, because you're right. That was a stand your ground case. This is Texas' version, sort of, kind of stand your ground. They have the castle defense there. And of course, that only works, Leslie, if you believe it is your home. So let's just talk about the key issue in this case. Did the jury hear enough to make them reasonably believe that the defendant thought she was in her apartment?
And I think that question is very key here, Michael, because what we have to remember is that the state has the burden of proof beyond a reasonable doubt to prove each and every element of murder. And that means that they have to prove that she intentionally killed him, which she had the intent to kill Mr. Jean in his own home. I question her testimony where she indicated that when she entered the apartment, she told him to put his hands up. So there's this question of reasonableness, if you will, as to if and when he did or did not comply. Why did she feel the need to use excessive force to shoot him? Regardless of whether or not she thought this was her apartment or not, were her actions reasonable at the time when she told him to put his hands up? Did he threaten her? Did he make her believe that her life was in danger? And I just haven't heard any information in this trial to make me believe that her life was in danger or that she thought her life was in danger.
Yeah, and I mean, that's obviously one of the key issues for this jury. In Texas, of course, if they apply the Castle Doctrine, then there is this kind of use of deadly force against whatever you perceive. So that's certainly a defense helpful standard in terms of whether or not this jury finds that the force she did use, even if mistaken, was reasonable. So let's listen now to more of the defendant on the stand. This is Amber Guyger from late last week. Mistake of fact. There's also a mistake of law defense, but that's not what we're talking about here. That'd be where you think, oh, I didn't know shooting somebody's against the law. My mistake. This is very different. This is the mistake of fact that Amber Guyger thought she was going into her apartment. It's not as simple as that, but boiling it down, that's about where we're going here. So, Michele Rayner-Goolsby, let me ask you this. First of all, should they have been given that instruction? Should the jury have been given the mistake of fact instruction?
I actually do think that the jury should have been given that mistake of fact instruction. And here's why. I fear that if the judge did not give that instruction, it could come back on appeal. And all of us know that no judge wants to be appealed. And especially a case that is like this case, I think it is a high-profile case. It is a highly political case. It is a high-pressured case. And I think that this judge, who was a career prosecutor, was literally covering herself, dotting her I's, crossing her T's. So I think that it had to come in because the judge doesn't want to be reversed.
Yeah.
I think it's a win for the defense. Most certainly, as a defense attorney, I would want that instruction in, because that goes to the crux of their case, that this was a mistaken fact. And so I think that it should have. I think it had to come in.
Yeah, and she did have some concern over a number of the instructions. This one less so, but she did ultimately make that decision. And she's the presiding judge there too. So if she's not comfortable with this, who else is going to be? This is Tammy Kemp. So let me ask you, Leslie. Because you're now involved. Let me see if I can get this right. I'm going to look at my cheat sheet here. You're now involved with the Governor's Justice Reinvestment Implementation Oversight Council, which is more the implementation of legislation that ultimately works its way down to prosecutors and others who are in the system. What do you think about the way the burden shifts in the mistake of fact defense? Now, once the defense says, hey, we're going to use mistake of fact, it's not an affirmative defense that the defense has to prove. It shifts the burden back to the prosecution to prove that any mistake was unreasonable. So now in your new lofty position of creating these scenarios, what do you think of that?
Well, I think that Michelle made a very vital point. Look, we want to make sure that when these cases are tried, that all the cards are on the table. Judges don't want to have their cases sent to the Court of Appeals for the appellate court to say, hey, look, Judge, you made a mistake. You presided over this case, and you're a judge for a reason. And so, the state and the defense both have to have the opportunity to bring forth these alternatives, if you will, in jury instructions. And, of course, yes, these are issues that come from these types of cases, are issues that help shape legislation. But these defenses, they do exist for a reason, because, the state does have the burden of proof, and, the police officer does not have any obligation whatsoever to take the stand or even put on a defense, regardless of whether she takes the stand or not. But she does have the opportunity to say, hey, look, this gives her the opportunity to present information to say the state's case, while it may be some jury persons may feel like the case is strong, this is why I believe that it's not so strong. And so she has that opportunity, and she avails herself of it.
This case has been very passionate, a lot of emotions on both sides, coast to coast. Everybody across the country is taking a side, to be honest with you, in this case. Well, the prosecution has kind of worked up over this case as well, as you might imagine they would be. Let's listen to some of the the closing argument here. And this is Jason Fine. They broke their opening up, and he took the first chunk. Let's listen to it, talk about his style and what he had to say. So there's a lot that goes into deciding who's going to give the closing, how it's going to be laid out. Michel Rayner-Goolsby, let me ask you, do you like it better when the prosecution or defense giving their closing is somebody the jury already knows because they've examined a number of witnesses or cross-examined a number of witnesses, or do you like kind of somebody arising from the table you haven't even seen before to lay out the case?
To me, what I would do and what I normally do is the person that's kind of the lead is the person that does the closing. I think that there's something to be said for a person that the jury has seen throughout the trial, whether it is, a 3-person defense or prosecution team or 4-person defense. The folks that are the ones that the jury has seen through the trial, I think that there's something to be said about that, because that, endears the jury to that person. You've kind of built up this relationship, if you will, with the jury. So I think that there's an important part of being that person that has been before the jury to make the closing, especially when you're the defense. I always say in my closings, like, I don't get to talk to you anymore. This is the last time I get to speak to you. So there's something, for me, it's really important that they get to hear from me if I'm the lead or I've been doing the heavy lifting of the trial.
Yeah, and Leslie, Ricard-Chambers, not only that, but all the way back to voir dire, the jury members you've been talking to really on the most comfortable, honest level you can before anything really begins. That's when you begin the relationship. That's the first date, as it were. And now, to go through the trial and either bond more with them or at least not be foreign to them. It just seemed to me a little bit odd to pop up there with kind of the prosecution had sort of somebody less involved. Maybe not a big deal. Let me ask you this. What do you think this jury is going to focus on as the single issue, Leslie, that would point them towards a murder verdict?
That's a good question, because as I was reviewing some of the information about this trial, what I noticed was the makeup of this jury. And I think that it's very important to note that there is a significant amount of minorities on this jury. And I think that's important because normally we don't see this type of makeup. We've got 5 African Americans, 5 Latino Americans, 2 whites that are on this jury. And when as I'm reviewing and looking at the differences in the closing arguments, the state's closing, in my opinion, was more practical based, if you will. Really just giving a refresher about the facts, and really the facts from the state's point of view. The defense started more with textbook. And so the question becomes, who do these jurors relate to? And what set of facts are they relating to? And so that's something that we've got to make sure that we keep our eyes on as we wait for the verdict in this case.
I think those are great points. And ladies, stay right where you are. We're going to come back. Michel Rayner-Goolsby, Leslie Ricard-Chambers, Michael James Bryant, Law and Crime Network. We'll be back right after this with more of the Amber Guyger case. Stay where you are.